Let's head to the Red Chamber for this next story. There's a bill before the Senate right now, Bill C-262. It aims to harmonize Canada's laws with the UN Declaration on the Rights of Indigenous Peoples. But the bill may not become law. Conservative senators are being accused of using procedural tactics to delay the bill and eventually run out the clock before Parliament rises, for summer break and the fall election. Those senators say they're worried the bill will give Indigenous groups a veto over resource projects. The UN initially adopted the declaration in 2007 to guarantee certain Indigenous rights that may not be addressed in other human rights charters, like the right to self-determination. Perry Bellegarde is the National Chief of the Assembly of First Nations. He joins me now. Hi, National Chief Bellegarde.
Hi, Bessie.
Nice to see you. I know you were expressing concern over what happened yesterday. These Conservative senators are saying is that what we outlined there in the introduction, that they're worried that this will give Indigenous groups a veto over resource projects. Does it give them a veto?
Well, I think more importantly, it's a bill that's been passed by the House of Commons. You know, Jagmeet Singh introduced a bill, or motion the other day, unanimously supported. Liberals, Conservatives, everybody in the House supported 262 and 337. And so that shows you that democratically elected MPs support this. And so now it goes over to the Senate. And because of procedural games, they're going to delay the vote on it. To me, I find that totally unacceptable. And I think the democratic process is in effect, and it's called into question. And I think there's enough time. There's 2 weeks left to pass not only Bill C-262, but Bill C-91 on languages and Bill C-92 on child welfare as well. And we have to put our energies there. And there's an obligation on the senators to follow the democratic process and get these important bills to vote.
The two latter bills that you mentioned, those are government bills. This was actually a private member's bill from the NDP that made its way here, right? I take your point on the concerns about unelected versus elected, but if the government had really wanted this to happen, wouldn't they have introduced their own legislation?
Yes, but this bill has been dialogued and discussed, and the support is clearly there for it. And so I think there's a huge opportunity now to pass it. And I think political will has been demonstrated. And I think it's incumbent upon the senators to get to the Senate and vote. You know, there's 104 senators. I'm encouraging all of them to get there, put the procedural wranglings games to the side, let the democratic process follow in the Senate, and get it to vote. That's not too much to ask.
What do you say to Senator Plett's concern, let's just say? And we will have him on later on the show. We'll put the similar questions to him. But his concern is that it's Section 32, because it states to obtain Indigenous nations free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. How do you interpret that?
I say you have to respect the rights and title holders. And the right to self-determination means the right to say yes or the right to say no. That should be respected. The UN Declaration doesn't contain the word veto. Every case has to be looked at individually and assessed based on its merits. The important thing is to get the rights and title holders involved sooner than later. And if this bill does not pass, I would say that it's a further perpetuation of colonialism. I would say that it's a further lack of respect for fundamental rights of Indigenous peoples. And I think it's going to create further economic instability in Canada. By passing 262 creates economic certainty. You know what the terms and conditions are. You know what the rules are. You get First Nations involved from sooner than later. And that's what you have to do if you want to get projects built.
They say they're arguing that clarity doesn't exist. They would like some clarity prior to that. I mean, this is what they're saying. I'm just saying they support the intent, but they want clarity around whether that's a veto or not.
Actually, that's been dialogued and discussed and debated, and then you have so much.
Is it impossible to get that kind of clarity, do you think?
I believe that it's already been done. I think let the democratic process take its place and get it to a vote. That's what the Senate is there for. It's already been unanimously supported in the House by vote. 262 and 337, Ron Ambrose's private member's bill. They should both be passed. Quit the procedural wrangling in the Senate, get them to a vote. That's what has to happen. And I think there's time. There's 2 weeks left in the sitting, and I think there's time. The political will is there. Quit the procedural wrangling, quit the gamesmanship, and get it to a vote. And I encourage all the senators to take their seats and get their job done.
What does it say, do you think, that it has been delayed now?
Well, it's going to have an impact on all the legislation because there's a delay. We were prepared to dialogue and discuss it and go clause by clause last night. But because of the procedural motion, which Senator Plett didn't agree with Senator Dick's motion to have the meeting, to give leave, it was cancelled. So that has an impact of delaying not only 262, but all the other important pieces of legislation. Like we talked about C91 on languages, C92 on child welfare, and they're just too vital to Canada as a country that they have to get passed.
Sometimes in defending their position, they have relied on an argument put forth initially by former Attorney General Jody Wilson-Raybould that the implementation of UNDRIP is sort of unworkable with Canadian law.
They say that, but she also retracted that statement.
Eventually, yes.
So they never say that part. They just
but she did initially say that.
She did initially say that, then retracted her statements. Because again, when you do the assessment and you have the time to digest it and dialogue and think it through, it's a good piece of legislation, and it should go. It should proceed.
I just want to be clear, though, on the point of what they're saying around the veto. Do you expect that sort of interpretation to be decided in the courts later, or do you think there is a solid, like, does that, they're saying the clarity doesn't exist and they want that clarity prior to passing this. Do you think that clarity does exist at this point?
I think
it exists.
What it is? I think it exists already, that you have to respect rights and title and jurisdiction. You want to build projects, I've always said this, build a respectful relationship with First Nations people first before you try to build anything. And you'll always find that sweet spot, the balance between the environment and the economy. No question. So it's recognition and respect of rights. By having this piece of legislation passed, Bill C-262, I say and I argue it will create economic certainty, not create more economic uncertainty. It creates economic certainty because governments will know and industry will know the rules of the game.
Is the rules as you interpret them, though, that, for example, if a pipeline was to go through a certain territory and one Indigenous group said, we don't want it to, that would be the end of that pipeline?
Well, again, you have to assess each case by
individually.
case.
So you're
individually.
You think it'd be individual.
And then some, because there's greater impacts on rights and title holders, and you have to respect that. You know, so some other First Nations along a pipeline route may not be affected as much as the First Nation that's there, and you have to take that into consideration. I'm going to always go back to respect the rights and title holders, always go back to build a respectful relationship first before you try to build anything, and passing Bill C-262 will create economic certainty in Canada, and that's what we're all after.
All right, I'll leave it there. Thank you, National Chief Bellegarde. Pleasure to see you as always.
Thanks, Bessie.
Thank you. Why don't Conservative senators want it to pass, and are they deliberately trying to kill this bill? Manitoba Conservative Senator Don Plett is the opposition whip in the upper chamber, and he joins me now. Hi, Senator Plett. Great to have you on the show.
Hi, Vassie. Nice to be here.
Okay, so from my understanding, from what I read, from what you've delivered, your speech that you've delivered and comments you've made, your big quabble with this is that you want clarity on whether or not Section 32 and other parts of the bill amount to a veto for Indigenous groups, by which some big resource project, let's say, goes through their territory. Is that accurate?
Well, absolutely right. Not just big resource projects. Projects of every size could be impacted by this. We have asked continuously whether or not this is a veto, and we have gotten no clear answers. Even Senator Sinclair said very clearly that we need to have a long discussion, particularly a committee, to determine what the experts who are behind the development of that wording had to say. And
so
we have had no opportunity.
Why not let it go to committee?
It is a committee. It's been in committee for 21 days. It's there.
But they were supposed to hear from some witnesses, right? And that's what happened yesterday.
Well, that happened yesterday only because the committee wanted to sit when the Senate was sitting. No, that's absolutely...
But you didn't want that to happen. You're the one that said no to that.
We said no to them sitting while the Senate is sitting. We have not said no to them sitting during their regular sitting hours. We have been very supportive of that. But they have not called the witnesses that we've asked. We won't get clarity if we get only one side of the story. We need to get both sides, which is what we've asked for. And no, we have not turned down any committee hearings other than the one they wanted to have yesterday while we were discussing very important legislation in the Senate, while we had 4 other committees meeting. They were meeting, the Aboriginal Affairs Committee meeting, was meeting on a non-government bill. Our rules are very clear in the Senate that we deal with government legislation prior to private members' legislation. That is what we were doing yesterday.
Can't you wear many hats at once? You know what I'm going to put to you exactly what they're accusing you of. They're accusing you of sort of using tricks of the Senate in order to delay this and run out the clock so that the bill just won't pass.
Well, again, that is just simply not true. Let me take you back, Vasi, and what Senator Sinclair has done. This bill, first of all, it was in the House for 769 days. It's been in the Senate for 371. First reading, May 31st, 2018.
Yes.
October 23rd, after 37 days, Senator Sinclair adjourns debate for 37 days. Finally, on November 29th, he speaks at second reading. November 29th. December 15th, we rose for the winter break and didn't come back till the middle of February. And on May 16th, I had an agreement with Senator Sinclair to refer it to the committee. As per an agreement between Senator Sinclair and myself, we had not stalled it. He guaranteed me that he would bring us both ministers, the Minister of Justice and Minister Bennett, to the committee. He has done neither. We want clarity. If the government wants to put themselves behind the bill, we want them to talk to us.
So are you saying that it is because those ministers, for example, won't appear, that you made the decision you did yesterday?
No, again, I made the decision I did yesterday is because the Senate was sitting till almost midnight yesterday dealing on bills like C-48, C-68, C-69, government bills.
Proponents of this bill would consider this important as well. And I know it's not a government bill, but it is part of the government's platform in order to harmonize those laws.
Well, in fact, it is not. The former Justice Minister said very clearly, and let me quote, simplistic approaches such as adopting the United Nations Declaration as being Canadian law are unworkable and respectfully a political distraction to the undertaking the hard work actually required to implement it back home in communities. Those were
she
Minister Wilson-Raybould words, and we want them to come.
She walked that back, though. She initially said that. You're absolutely right. She said it was unworkable. She then walked that back, and the government wholly endorsed.
And we asked whether they would bring Wilson-Raybould back to the table, to the committee, to explain why she said it, and then walked it back. I don't think it's unreasonable, Vasi, for us, before we pass, especially private members' legislation, that we have clear answers to what implications this will have for our entire country.
The proponents of the bill also say that the House has wholly endorsed that this get voted on at least voted on. Okay, you can oppose it. You know what I mean? And you clearly have reasons to oppose it, and I'm sure they're very valid. But why not just allow it to go through the process? You're not elected. Allow it to go through the process. Cast your vote and let the process play out.
But that is the process. The process in the Senate is dealing with government legislation when we have it before us. The Aboriginal Affairs community has two bills that Chief Bellegarde talked to me about today. Bill 91 and 92, government bills. They were his priority. He told me they were his priority. He said, Senator, are you going to get these two bills done before you rise for the summer? Those were his priority. Those are my priority. Those are government bills. That is what I've been sent here to do.
If this was a government bill, would your approach to it be different?
Entirely different, because the approach of the Senate would be different. It would have gone into committee and they would have dealt with it. Now, the committee is instructed to deal with whatever government legislation they have before it, before they deal with private members' legislation,
Can they do both, though? I mean, what they're saying, what, for example, National Chief Bellegarde is saying is that you're standing in the way of that happening, and deliberately so.
That is not what Chief Bellegarde told me when I spoke to him on the phone today. He said 91 and 92 are my concerns.
He didn't say anything about this one?
He mentioned 262, and I said, what's your priority? He said C91 and C92. Those are my priorities.
Okay, Senator Platt. Appreciate your time today. Thanks for coming in.
Thank you.
Hi, I'm Vashi Kapellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video. Thanks for watching.